Thank you for inviting us to your meeting so that we can share with you more details about the Oregon Department of Justice's Bias Crime and Bias Incident Hotline. The hotline is a data collection and victim support hotline created by Senate Bill 577, passed by the Oregon legislature in June of 2019 in response to the steady increase in hate crimes which have unfolded in dramatic and startling fashion. Our speakers today, myself, Faith Waters, Director of Civil Rights at the Oregon Department of Justice, and my colleague Johanna, who is the Oregon Department of Justice's Bias Response Coordinator. First, I'd like to talk to you today about some key features of Senate Bill 577, which is our Bias Incident and Bias Crime Law. As you know, Oregon was among the first states in the nation to pass a hate crimes law back in 1981, and the law had had few meaningful changes for decades. Beginning in 2016, leading up to the presidential election, Oregon had a significant increase in hate crimes, including the murder of Larnell Bruce Jr. in August of that year. And in 2017, the hate-motivated deadly attacks on the Max. The Attorney General began a statewide listening tour, and she heard from people who experience hate and bias. She created a task force comprised of community members, folks from populations impacted by inequity, and people working within the criminal justice system, and tasked them with studying hate-motivated crimes and making recommendations to strengthen the hate crimes law and government's response to victims of bias crimes and bias incidents. In 2019, the legislature passed Senate Bill 577, which was declared an emergency and effective upon passage. Key features of the law. The law includes changes to the statutory language from intimidation to bias to better reflect the behavior that was occurring around the state. The crime classifications remain the same. There are felony and misdemeanor offenses that track the former intimidation statute. But this law also clarifies that gender identity is a protected class included in this law. The law created a new legal term, the bias incident. From the Attorney General's listening tour, she learned, and the task force also learned, that bias incidents were not really being addressed, or they were not being addressed in a way that helped the victim. So often, especially within the criminal justice system, we focus on the perpetrator of harm. And for bias incidents in crimes, we're losing sight of the person, the family, the neighborhood, and the community harmed because of the bias. Thus, another feature in the establishment of this law is the hotline, an actual telephone hotline for victims and witnesses, answered by an actual person, and that's Johanna. The hotline went live in January of 2020. It's a place where folks can receive support, hear validation that their experience was indeed targeting or was biased, learn about options for community support or affinity-based support, and talk about options for next steps if folks are interested, including potentially with law enforcement, if that's a safe option, and to places like BOLI, the Fair Housing Council of Oregon, the Governor's Department of Human Services, Ombudsman's Office, Oregon Department of Education, and others. Another feature of the law is data collection. This law requires that the Oregon Department of Justice, Oregon District Attorney's offices, and all Oregon law enforcement agencies collect and share data with the Oregon Criminal Justice Commission. So for the first time, we'll be able to track hate and bias occurring in our state. Law enforcement entities must report to the state police. District attorneys must track and share all bias charges presented to the district attorney's office for prosecution, the bias cases issued by the district attorney's office, bias charges that were indicted, all sentencing enhancements requested for bias crimes, sentences imposed, including conditions of supervision, all the charges to which a defendant enters a plea of guilty or no contest, as well as trial outcomes for bias charges. All of this information will be shared with the Attorney General's office, with the public, the Governor's office, and the legislature to help improve the law and our response to hate and bias. So bias crimes. What are we talking about? It's important that we start to educate communities about what a biased crime is. A biased crime occurs when a person makes threats to another person, their property, including their pets or their family, or if a person tampers with or damages their property, or if they put hands on or make offensive physical contact, such as spitting or shoving, or if they assault another person or use weapons against a person, or to scare another person, motivated, at least in part, by bias against the other person's perceived race, color, national origin, religion, gender identity, sexual orientation, or disability. The targeted person need not belong to that protected class. This crime is about the perpetrator's perception, whether accurate or not, of the other person's protected class identity. So I said before, the class C is that bias 1 is a class C felony. It has a felony classification. At ORS, which is Oregon Bias Statute 166.165, that's our bias statute. This was formerly the intimidation statute. The statute no longer requires co-defendants to act together to be charged at the felony level. Basically, if a person causes physical injury with a weapon or otherwise, or places one in imminent serious fear of imminent serious bodily injury, or does so because of a perception of another person's color, disability, gender identity, national origin, race, religion, or sexual orientation, then that person has committed a bias crime in the first degree. And I know some of you might be asking, how did the legislature determine that it was these 7 protected classes that warranted inclusion and not the other protected classes, like age, political affiliation, or housing status? Well, the AG's listening tour, information from the AG's listening tour, the task force, crime statistics, and public testimony demonstrated that these are the classes that are targeted the most. The Class A misdemeanor, essentially the crime of bias in the second degree. It's a misdemeanor. It occurs when a person tampers with the property of another, intentionally subjecting another to offensive physical contact, or intentionally subjects that person to alarm by threatening to inflict serious bodily injury or cause substantial damage to the property of another person or a member of that person's family, based on the color, disability, gender identity, national origin, race, religion, or sexual orientation.
So we have provided law enforcement and prosecutors with some formulas to guide them in investigating and charging bias crime under this new framework. Many law enforcement and prosecutors are familiar with some basic formulas. Theft plus force equals robbery. If you take my wallet and you shove me, that's robbery in the third degree. So we're introducing formulas with crimes we know law enforcement and prosecutors are already familiar with, like criminal mischief, harassment, assault, and unlawful use of a weapon. When a bias element exists, like a slur or hate speech, and one of those crimes occurs, you very likely have a bias crime. Here are some of the examples of some formulas. So we have bias plus harassment equals bias in the second degree. If menacing occurs with bias, minimally, it's bias in the second degree. It also could be bias in the first degree. When we have bias plus vandalism, also known as criminal mischief, that's a bias crime in the second degree. If we have bias plus assault in the fourth degree, we're looking at bias 1. And same with bias plus unlawful use of a weapon. We're looking at bias in the first degree. So if you can charge menacing and the report is littered with racist words, you can likely charge bias. So going back to our previous robbery example, if you take my wallet, shove me, and call me a slur, we're looking at a bias crime, minimally bias in the second degree. So again, these may be new concepts for folks, but we're trying to educate in a digestible manner that speaks the language that folks are already familiar with. So let's talk about bias incidents. So the definition of a bias incident means a person's hostile expression of animus toward another, relating to the other person's perceived race, color, religion, gender identity, sexual orientation, disability, or national origin. of which criminal investigation or prosecution is impossible or inappropriate. Bias incidents do not include any incident for which probable cause of the commission of the crime is established by the law enforcement officer. So our administrative rule at OAR 137-065-0200 sub 2 defines a hostile expression of animus as a person's act, process, or instance of representing or conveying deep-seated ill will, antagonism, or hostility, even if controlled, in actions, words, or some other medium. So some examples of bias incidents include racist graffiti, where we don't have a defendant or a suspect that we have probable cause to arrest, flags or signs promoting exclusion or white supremacy, a noose, mimicking, mocking, offensive jokes, discrimination in housing settings, microaggressions at work, refusal of service at a business based on someone's protected class. One of the great things about Senate Bill 577, now codified under ORS 147380, is a law enforcement mandate to refer victims of bias incidents to either qualifying local victim services or the bias response hotline. Qualifying local victim services will be designated by the Department of Justice, but for now, the process is simple. If law enforcement learns of any bias incidents, including folks using racial slurs, religious slurs, anti-LGBTQ slurs, or other inappropriate language, offensive jokes, targeting somebody's protected class, law enforcement shall refer the reporter, the victim or the witness, to the hotline. It's not you might want to, it's not it's best practice, it's not you can refer, it's you shall refer. So in order to fulfill the intent of the statute, which was to improve government's response to victims of bias, this referral must be made. We recognize that the referral is a new requirement. The hotline has only been open since January of 2020. So we thought law enforcement might need some tools to help them respond to bias victims. As you can imagine, law enforcement plays a key role in how government responds to bias crime and bias incidents. Historically, approaches to bias incident complaints ran something like this. At best, sorry, there's nothing we can do, it's a free speech issue. But with the new law, there's something more law enforcement can do to help with their response. We created some tools. We created a law enforcement bulletin explaining the new criminal and incident laws. We created referral and resource pocket cards for law enforcement. We have both a victim referral card, allowing law enforcement to hand a card over to a victim on scene for a place to receive support on the hotline, as well as a law enforcement resource card, linking law enforcement directly to our online toolkit filled with resources and language to help them respond better to bias. Also included in the toolkit is a listing of trauma-informed messages and language that law enforcement can use when they talk to bias victims to promote human dignity and respect and remind people how courageous they are to report their bias experience. In the toolkit, we have an online bias incident reporting portal for law enforcement to report bias incidents. We also have a supplemental report form for bias investigations, whether criminal or incident, to help guide law enforcement in their investigation of bias, reminding them of questions to ask on scene, and including a list of nationally vetted bias indicators that should flag possible bias motivation for law enforcement to look further into. We also created a public service announcement that is still airing on TV and radio. Law enforcement is still learning, and we hear on the hotline that some agencies are still not responding in a manner that reflects respect and dignity, and does not include the mandated referral to the hotline. So again, we urge folks to use this toolkit to help improve response. So what happens when folks report to the hotline? People can report anonymously, either online or by phone, and they can request a call back or choose not to leave any contact information if they just want to document the bias. If folks choose to receive a call back, hotline advocates go through an informed consent process with callers to be sure they're making an informed decision about engaging with us. We are a confidential hotline, with the exception that we are mandatory reporters of child abuse, elder abuse, and abuse of folks with disabilities. We make sure that if a caller is represented by an attorney, that we have permission from that attorney to speak with their client. We ensure that folks know that we are collecting de-identified data, things like their county, the nature of the bias, whether it was harassment or assault, institutional bias, doxing, and more. We track the bias motivation or targeted protected class and other identity markers if folks feel comfortable sharing with us. And finally, we explain the limitations of the hotline, that we do not open our own investigations or sanction bias perpetrators. The hotline is here to support folks in the aftermath of bias. We help folks process what has occurred. We help folks identify or put a name to the experience. For many, this is the first time they've disclosed and the first time that someone has said or validated that what has happened was not okay, that in fact it is targeting and that it is bias. And we help folks decide what next steps they may want to take. Perhaps accessing support through a community-based organization that we can refer to, or referring to an existing investigation process with BOLI or the Oregon Department of Education or otherwise, and or reporting to law enforcement if criminal conduct has occurred and if that is the reporter's choice. The hotline is victim-centered, meaning the person who calls drives the conversation, decides what information they want to share, and decides what next steps they may want to take. We also operate with an understanding that this bias experience was likely traumatic and that folks come to the table with trauma in their histories already. If they need to process in multiple contacts with the hotline, that's okay. If they need long pauses of silence to process, that's okay. If they need emotional support and validation, that's okay. If they need things explained multiple times, that's okay. It's a reflection of our support of their trauma histories that we allow folks to come as they are and receive support as they need it. We do make a determination of bias conduct on the hotline, whether it's a hate crime, a bias incident, bias against a class not protected under the statute, or if bias criteria has not been met. And we engage in extensive safety planning, making sure that folks have the tools they need to make safe choices moving forward.
Now, it's been 1 year since the hotline's been going on, and 20 months since the law has passed. Let's call bias what it is. We face some challenges and we have some practitioner tips, and let's call bias what it is. When we hear offensive language, let's not ignore it. Put it in a document, word for word, in quotation, in your reports. When we exclude that language, which may make us more comfortable not to think about it, we're actually erasing the bias experiences. So it's important to document it. Note that history, especially as we know it, that bias incidents such as offensive language often precedes bias crimes. That's why it's so important to document the language that was used in these reports.
We want to make sure that folks have resources, so make that referral. We have provided law enforcement agencies with pocket cards that each have scannable QR codes that link to our website for victims and to the toolkit for law enforcement to help folks in the aftermath of bias and in bias response. These are printable pocket cards, and anyone can refer folks to the hotline. Also, anyone can report to the hotline. Remember, we want victims and survivors to make the choice about where their personal information and experience goes, especially in a law enforcement context. What is safe and appropriate for you may not be for others. But if you see something, report it. We have 2 online portals, one for community and one for law enforcement. Referrals can stop this momentum of hate and allow us to meet these challenges early.
Regarding investigations, we have included bias indicators in our law enforcement toolkit, and sometimes other agencies get involved in investigations, like the FBI might be interested. So these investigations should be thorough and look deeply into the motivation of the perpetrators. Use our supplemental form and to track those bias indicators and write a report every time, even for bias incidents. Again, bias incidents can be a precursor to bias crime, and having that information documented in our system is so important. And in some cases, the federal law enforcement may be interested in the case as it develops as well.
In terms of charging decisions, we encourage law enforcement and prosecutors to use our formulas and to charge cases with a willingness to educate your jury pool and believe in your jury pool, that they would see these actions for what they truly are.
In negotiations, there are plea agreements, and their negotiations are precursors to the plea agreement. When prosecutors do charge these cases of bias, they can incorporate the victim's voice into their negotiations. And while victims have a constitutional right to confer with prosecutors on violent felony cases, we suggest that prosecutors consult with the victims in all bias cases, hear what they would like to see as an outcome, and hear what they see as justice to allow that to lead the conversation. Victim's voice is really important.
In terms of victims' experiences, remember that a victim's experience with law enforcement, prosecutors, systems, and individuals in the aftermath of bias have ripple effects, just as bias experiences have ripple effects. There's a whole body of research around the concept of procedural justice that reflects that when we see the humanity in others and treat them with dignity and respect, and ensure that folks have a voice and a meaningful role in the criminal justice process, we start to repair past harms. And we develop rapport with communities and folks long impacted by inequity.
To law enforcement and prosecutors, if you do not find bias, please explain it to the victim and explain why. Refer these folks to the hotline for support. We have a bit of a legislative gap when prosecutors don't charge the bias aspect of these cases or issue a no complaint to the charges altogether. The bias incident hasn't been referred to the hotline, and the bias crime isn't referred to the victim assistance program for support within the DA's office. So we're asking that the bias cases that are no complaint in whole or in part, that those victims from those cases be referred to the hotline so that we can support them. Just a few of the challenges and some of the tips.
So we have this bias map that tracks the bias that has been reported to the hotline throughout the state. Our official data that is processed and analyzed by the Oregon Criminal Justice Commission is on our data dashboard on our website at standagainsthate.oregon.gov. And again, the reports to our hotline are compiled and analyzed by the CJC and posted on a clickable map on our website so that the information is digestible by location, by community, by conduct, by identity, by bias determination, and it tracks victim services provided. The purpose is to make this information public and allow recommendations to the governor's office, legislators, and to the Attorney General regarding the findings.
So this is the information regarding how to reach us on the hotline. Our number is 1-844-924-BIAS. That's 2427. The hotline is answered during normal business hours. We also have interpreter services available for over 240 languages. And for our deaf and hard of hearing communities, we use the 711 relay system. During our contacts, we use a trauma-informed approach, victim-centered, culturally responsive approach. We've worked closely with our community partners to make appropriate community referrals to further assist our victims. You can also reach us, if you don't want to talk on the hotline, you can also reach us online at standagainsthate.oregon.gov. Oregon is spelled all the way out in that URL. That'll take you directly to our webpage. You'll see the portal where you can make your complaint, file your complaint online. And you'll see all of the resources that we have available. Our webpage contains quite a bit of information about the law, about the hotline data dashboard, how to report bias, either using the hotline or the online portal, as well as what you can expect if you call the hotline. There we have our tools for law enforcement, tools for victims of bias, and resources for our service providers. Please check it periodically for updates.
So thank you so much. We can respond to bias when we work together, and we can stop bias in Oregon when we support folks and we recognize that the way that we treat people is so important. Thank you very much. Now?
Thank you so much for your time and attention today. You know, we all have a role to play in eliminating hate and bias in our community, and I'm so glad that you've taken this step. When we respond to those who've been harmed in our community, we're also playing a crucial role. So thank you for endeavoring to play a role in that. And so collectively, we can all make a difference together. Thank you again.